Well, as you know, once I'm on a roll, I'm on a roll. And I'm Black Bright News, and I'm doing a couple of videos on this new rule that came out on the 11th of November impacting overstayers. Um, I didn't realise the full depths of the implication of the new rule, but ordinarily they have something called a overstayers exemption, which means that if somebody's overstayed for like 20, 25 years and they'd established themselves into the UK and integrated well, they could actually be regularised into the UK, even though they originally arrived in the UK unlawfully. Now, that the way that they entered the UK doesn't necessarily mean on a boat or by surreptitious means. It could also mean that they met somebody, they got married, they thought it was a legitimate marriage. And as you know, I work in domestic violence with safeguarding children, and we find a lot of incidences where somebody's married somebody in the UK and hoping to regularise and have a happy family, and the marriage is broken down. The spouse, the perpetrator, has become abusive. It's got something over the person that they married, so they withhold the passport. They know that they can get that person to do anything that they want because they are reliant on them to give them, to regularise them, and so that they can have the spouse visa. And what sometimes happens is these people overstay and they're in the clutches of abusive spouses. I'm just giving you an example of how somebody can overstay. And you might say, well, if they're being so badly treated, why don't they go back? Sometimes they've given up everything to come here. Who knows? Anyway, the Home Office is closing that loophole. It's not going to be so easy for those people who have lived here for 20, 30 years, regardless of what they've done, to be able to remain in the country. They've given themselves something that can allow them to still be deported, regardless of how long they've been here. So, the crux of it is that, let me just read my notes, otherwise I'm going to run out of time. So, what have I got here? A long-standing overstay exemption. It refers to a special immigration policy or discretion that allows someone, who has lived in the country for a long period of time without valid immigration status, i.e. overstayed, to avoid removal or qualify for regularisation, permission to stay. Long-standing overstay exemption is a term used to describe exceptions or discretionary policies that protect people who have been living in the UK unlawfully for many years. I've got two sources here. So, who is excluded from the new framework suitability? This is taken from the Electronic Immigration Network, and it says Appendix EU and EU Family Permit Asylum, Appendix Settlement Protection and Appendix Service Providers from Switzerland. An important addition under the new regime introduced a safeguarding-based refusal ground. Under SU 161, entry clearance under Appendix FM, which is the family one, must be refused if the decision believes the applicant's parents or their parent or their partner poses a risk to the child applicant. So they are thinking about children now, so not just because they're coming over here with two kids, are they treating that kid right? The new suitability rules also redefine what constitutes a breach of immigration law. Under SU 1.11.4, an applicant will be considered in breach if they have overstayed their visa, breached conditions of leave, entered illegally, or used deception in a previous application. Before, that didn't matter. So now, under these new suitability rules, if you've breached an immigration law, you could have been here 20, 25 years. And if you've overstayed, you can be deported. That's in basic terms. Of course, you have to go and see a lawyer, get a good lawyer to kind of interpret what these new rules, because they are open to interpretation. And depending on how qualified the solicitor is, you've got a lot of solicitors who are giving advice and charging large fees, and they're not qualified. So just be careful. Just make sure that they're qualified at OISC level 3 and above. Proper immigration lawyers. I'm only OISC 2. I'm not qualified to give advice, but you might find they might show you a certificate, you don't know what it means, and you're getting ripped off. Take your money, they're still not making any difference to they're still not securing your safety or your or your stabilisation. Exceptions for overstayers. The long-standing 14-day grace period for late applications will continue under SU 113.1 with allowances for good reasons beyond the applicant's control, as well as exceptions for those affected by COVID-19 pandemic and exceptional assurance. I mean, that was, 4 or 5 years ago, so I'm not quite sure how that applies, but we don't know. Applications to human rights-based routes, that might be of some interest to some of you. The most impactful change is that part suitability will now apply in full to human rights applications such as Appendix FM and private life routes. Under the new rules, even human rights-based applications can face mandatory refusal for any custodial sentence over 12 months, discretionary refusal for lesser convictions or repeat offending, mandatory re-entry bans for immigration breaches, and discretionary refusal for previous overstaying or breaches of conditions. In other words, if you're a repeat offender, you don't have to have been in prison for 12 months. If you're a repeat offender and you've done a lot of little offences, this can still apply to you. It affects your suitability, it affects your credibility. I think it should be eligibility, suitability and credibility. But the third one is substance, which I guess means the same thing. The Home Office acknowledged that refusals must not breach ECHR obligations, where refusal under this part would be incompatible with the UK's obligations under the European Convention on Human Rights. There are specific rules set out with regard to the approach to be taken. So, like I said, there's always an exception to the rule. There's always loopholes. Always trust a good lawyer. Get them off of www.gov.uk. The Home Office has got a website where you can find legitimate lawyers, even some of the citizens' advice bureaus. They can direct you to get an authentic lawyer. I know some of you must feel desperate in these circumstances because up until now, especially those on the 20-year route, they've been here for over 20 years. They're in the middle of it and they could be thrown out because this is not retrospective. It doesn't matter whether or not you have applied before the 11th of November. Everything kicks in on the 11th and afterwards. So old applications will now, as far as I understand it, will go by the new rules. So you just have to make sure, basically, you've got a clean bill of health. Really, that's what it's about. No convictions. You've not overstayed, you've not come into the country illegally, you haven't got any prison record or any kind of debt or anything that could make you suspect. That's basically what I'm saying. And that's all for now. Sorry about my croaky voice. Speak to you soon.